Assalamualaikum warahmatullahi wabarakatuh. My name is Afifah binti Mahathir and my metric number is 057702. Me and my group mates are from Group 9. We are going to talk about real estate. My part is private caveat. A private caveat is a legal notice entered by an individual. It is designed to make sure that the buyer of the property has protection against the owner who sells it to another party. It is usually a mechanism to ensure your intention for purchase. If you have a caveat lodged against a property, the owner is prohibited from selling until the caveat is settled. A private caveat is usually entered to preserve the land in its present state until the dispute on the interest or title in land between the competing parties in court is settled. Protect an individual's claim over the land and offer a heads-up to potential land buyers of one's interest on the land. When a private caveat is successfully lodged, the land in question can be dealt with in any way only when the caveat is removed. The person who lodged a private caveat is called a caveator, and the person whose land is affected by such a caveat is called a caveatee, according to the legal terms. A person can lodge a private caveat when the person is claiming title or interest to the land, who claim beneficial title to the land and on the behalf of a minor. Claiming for the beneficial title of the land, this section is under Section 323 National Land Code. For example, you have purchased a property, a valid SPA, and you have paid the prerequisite deposit for the property. Anyone claiming the title over land or claims having any interest for the title of the land also can enter a private caveat. For example, if someone says that the land belongs to him, then he may enter a private caveat. A private caveat is commonly entered when the situation is when someone has entered into a sale and purchase agreement to purchase the land and all the money needed has been paid out, but the vendor has refused to complete the sale. Next, when a beneficiary is under a trust to avoid dealings by the trustee, and the last situation is when a company or person has taken a charge over the land but the charge is pending registration. Even when there is no suitable legal basis for doing so, a private caveat may be included. For example, as security when there is an ongoing civil dispute or for the recovery of a debt. In such circumstance, these caveats can be removed and claim for compensation can be completed against the party entering the private caveat for any loss or damage suffered. That is all from me. Thank you.
Assalamualaikum warahmatullahi wabarakatuh. My name is Yasmin Shamini binti Muslimin and my metric number is 057705. Once a private caveat has been successfully lodged, the land cannot be dealt with in any way until the caveat is withdrawn. The individual who files a private caveat is referred to as a caveator, and the person whose land is impacted by the caveat is referred to as a caveatee. Under Section 323(1) National Land Code, there are only three instances whereby a person can lodge a private caveat, which is, the first one, a person who claims ownership or an interest in a piece of land. Second, a person who claims beneficial title to a piece of property. And the last one, a person who is claiming the beneficial title to land on behalf of a minor. A private caveat can be also deleted before it expires by the creditor himself, a person who owns or has a registered interest in the property in question, and the last one, a person who has been granted permission by the court to remove a private caveat, usually on the grounds that the private caveat has harmed his or her rights or interests in the property in issue.
Caveator is responsible for proving why a caveat should be lodged or renewed. Caveators who lodge or fail to remove a private caveat incorrectly or without proper explanation shall be liable to pay compensation to the caveatee or any other person harmed by the lodgement of such private caveat, such as Section 329 NLC. Here are the samples of Form 4, Application Form for Entry of a Private Caveat, Application Form for Entry of Lion Holders Caveat, an application form for removal of private caveat, and the last one, application form for notice to withdraw private caveat. That's all for me. I will be passing to the next member. Thank you.
Hi, Assalamualaikum. My name is Asliza binti Arshad. My matrix number is 057620. Now we go to the advantages and disadvantages of private caveat. Advantages. First, it can protect the rights of individuals on land. Second, it can prevent any fraudulent property transactions. And third, be able to maintain the status quo of the land while awaiting a court decision on the matter. Next, disadvantages. Number one, if you make a caveat that is not considered valid, you will have to pay compensation to the landowner for any damage or loss. Number two, only the registrar of titles, land administrator, or court can issue a caveat. Lastly, the entry of lienholder caveats is prohibited.
Hi and Assalamualaikum. My name is Siti Nur Elena binti Abdullah and my matrix number is 057608. What is a lien holder caveat? A lien holder is a legal interest. A lien holder's caveat is equitable in nature, so it is an equitable charge or deposit charge. Section 281 of the code states that any landowner or lessee may, for the time being, deposit his issued document of title or duplicate lease with any other person or body as security for a lien. Where is a lien holder caveat frequently used? It will be used when the loan is of a short duration and involve the transfer of land, and the memorandum of transfer is pending adjudication. The right of the land as security for a loan and hold an issue document of title to the land, he becomes entitled to the lien over the land in question. The lien serves as adequate security for the loan. The registration of the lien holder's caveat covers the lien holder's right as provided in the court and notifies the world of the presence of its interest in the land, establishing and lien holder's priority beyond doubt. The primary effect is a lien holder caveat is that the lien becomes a secure debt. If the debt is unsecure, the lender can only trade. It is civil claim that can only be enforced against the borrower. It is not enforceable against the land of subsequent purchaser. If a lien holder caveat is recorded, the lender is entitled to be paid from the proceeds of the sale and the land in question if in first sale is required. A lien holder caveat has the same effect as a private caveat as long as it is in force. In short, the lien holder caveat has a same prohibitive effect against subsequent registration of negotiation, endorsement in respect of exempt tenancies, and entry of subsequent lien holder caveat of the subject property. However, unlike private caveat, it functions as a form of security and convert a lien into a secured debt. A lien holder caveat also may be withdrawn or cancelled in some circumstances, such as it will be cancelled when the lien holder withdraws their lien holder caveat, or in situation where the land or lease subject to the lien holder caveat is sold pursuant to an order of the court respect of the judgment for the amount due to the holder of the lien. Next, it is circumstance where upon proof that all sum under the lien have upon fully paid, the registrar may cancel the lien holder and it cancelled by court's order. The main effect of the registrar caveat is to prevent the registration of any further dealing in the land after its entry. It remains the effect indefinitely until cancelled by the registrar, either on his own motion or the application of the landowner, or the response to the court order issued under the section 418 of the court against his decision to refuse an application for cancellation. That's all for me.
Assalamualaikum. My name is Nuristi Koma binti Marsaid. My matric number is 058800. So I will continue my part, which is advantages and disadvantages lien holder caveat. So I will start with the advantages. Even for a short-term loan, a legal charge is clearly superior and much preferred type of a security. However, because the lien caveat holders is not registered on the issue document of title, some borrowers prefer it. Second, there is no ad valorem stamp duty on a lien holder's caveat. The disadvantages is first, there is no other statutory remedy apart from the order for sale, and there is no right to the transfer of the security. Second, the lender must regard any possible claim for compensation for the wrongful lodgement of a lien holder caveat or failure to withdraw it. Last, the lender must conduct a research on the registered document of title to the land and ensure that the person providing the title that as a security is the registered owner of the land.
Difference between lien holder and trust. A lien is not registered by the lien. A trust is a transaction through which the registered owner of the transfer lands or lease use it as guarantee to repay another person's loan, annuity, or any other regular payment. For lien holder, according to Article 281/1 of the National Land Code, a lien can be established on any alienated land or any lease. For trust, in order to create a trust from 16A must be registered. For lien holder, a lien is not required to create a registration form, so it is faster to create a lien compared to the register fee. For trust, there are two statutory remedies, that is the defendant or defendant enforce the accusation in the case of a breach of contract by the guarantor. For lien holder, instead the lien holder can apply for warning from the lien holder to protect their interests. For trust, there are two types of legal remedies: are application for possession or order to sell land.